Welcome. My name is Tim Martin. I'm the Associate Director of the Innovation and Commercialization Unit within the Bezos Center for Sustainable Protein. I also have a role within the Tech Transfer Office at NC State as Interim Assistant Vice Chancellor for New Ventures and Investments. We're here today to talk about intellectual property. So we have one of our experts from our team from the Office of Technology Licensing Office, and we will go in depth into the nuts and bolts of what is intellectual property, hopefully understanding how to get engaged with our office or your office if you're at another institution, and kind of the nitty-gritty kind of details about what makes a patent and what makes something patentable, going in through all those details. So we will hopefully go through this relatively swiftly and then provide plenty of opportunity for question. I'll be manning the Zoom, so if you want to type a question, if you want to come off mute and ask a question, raise your hand during the call. I want to make this as informal as possible. We are recording it, so if the folks who couldn't come today will be able to view it later and get their credit. I also shared a survey link in the calendar invite. I will share it in Zoom as well and make sure to follow up with you all with an email. In order to complete the training, you do need to fill out the survey. It's 5 questions, very brief, hopefully not too painful. The idea is to show that you've learned kind of the basics of what we're going over today, and going forward, being able to access our office as we think about intellectual property. And then to remind everybody, I sent 2 invites today and Friday. If you have the ability to come on Friday, we're going to be talking about the new ventures and opportunities, so startups, getting companies formed, and what are the opportunities that exist to commercialize your technology on campus, both at NC State and the partner institutions. So with that, I'll turn it over to Devesh and take it from here. Thank you.
Thank you, Tim. Good afternoon, everybody. We've got some folks here on site, and I guess a number of people online. And I'm going to just jump right in. The outline of the talk today, we're going to have a little introduction on the topic of intellectual property, what we do, what we hope to accomplish. Also, we'll get into patents and intellectual property, give you a background on that. By no means will you be an expert, but it'll give you a working knowledge so that your work with the Bezos Center can be implemented commercially. And if not there, then maybe perhaps another time in your career. We'll cover the different types of intellectual property. What are the standards for patentability? Because generally innovations are covered by patents. I'll touch upon the policies here at NC State for intellectual property, talk about what an invention disclosure is, how that process goes. Then contracts, why we need confidentiality agreements. Why we need material transfer agreements. Why are these part of the process, and when do those happen? Then we're going to talk a little bit about how you evaluate an innovation and determine if there's an invention, and then take steps to try to get it out of the lab and into the market. Part of that process is what my office does, which is licensing that technology. So first, I think it's really important to emphasize we're here to make a difference. And how do we make that difference? Well, first of all, we want to improve lives, benefit society. I think that gets to the goals of the Bezos Center. We want to have discovery with the purpose of implementation of that discovery. Let's see, jumped ahead. How do we then move that innovation into commerce? Sometimes we may have to partner with industry. And when we do that, it could be with funding, where the industry partner may or may not have an option to license the discoveries that come out of that. Could also be a collaboration. Why is a collaboration good? Well, maybe there's expertise that reside with the 2 entities, and working together, there could be a synergy. So the basis of intellectual property rights actually comes from the Constitution. Article 1, Section 8, Clause 8. Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their writings and discoveries. Writings, well, that's copyrights. Copyright protections last 70 years after the author's death. The example many people know about are the original Mickey Mouse, Steamboat Willie. Disney fought long and hard to change the law from 50 years after the author's death, Walt Disney, to 70 years. So some of those early copyrights to Mickey Mouse are now expired. Inventors and discoveries. Well, that's patents. Patents will last 20 years from the date of application. Under the old law, it used to be 17 years from the date the patent issued. We'll go through some timelines and illustrate what that means about date of application and date of issuance. If you've got further interest to learn more about intellectual property, I've included a link here in the slide. This is a website maintained by the U.S. Patent and Trademark Office. Well, as I've mentioned, one type of intellectual property is that of patents. Another is trademarks. Trademarks can be quite valuable. Of course, there's the Apple logo. This is how you have some certainty with brand protection. This is also how companies enforce their brand rights against counterfeiters. Copyrights. We talked a little bit about that as well. Some of you may have past knowledge of Coca-Cola and how their formula is a trade secret. If you ever get to Atlanta, to the World of Coke, they have a nice tour and they talk and show you the vault where the recipe for Coca-Cola is stored. Now, this is a video. It may not work here. I'll just direct you to those slides, which you'll have later.
Yes.
Okay, we'll try it. Okay, we'll skip that. Anyway, you guys can see that later on your own. It's just a nice little 2-minute video about how intellectual property impacts our daily lives. So, jumping ahead to patents. Well, a patent has to be useful and it has to be new. Remember, the Constitution said Congress shall have the power. Well, Congress has written the laws on patentability. First thing, it has to be useful. That means, and recently the Supreme Court's gotten heavily involved on what is patent eligible. So I'll jump straight to what's not eligible. Abstract ideas are algorithms, products of nature, or laws of nature. Going back 25 years to the Human Genome Project, there were a lot of patent applications and issued patents related to DNA sequences of proteins, that encoded proteins. What is patentable are the processes, the machines, articles of manufacture, and compositions of matter. Oh, sorry. The next standard is enablement and written description. Well, what does that mean? That means the patent has to teach you how to make and use the invention. I'll give you a quick example. There was a patent application from a French cosmetic company that included components of a meteorite. They actually showed in a petri dish that their cosmetic stimulated the multiplication of keratinocytes, skin cells. And so they wanted to patent that. What sank their application for a patent, though, was one of the standards of the patent is when the patent expires, the public has to be able to make and use it. Well, if you don't have the starting material of that meteorite, you can't make it. And the literature showed that the splatter field for that meteorite, it had already been gathered up by scavengers and other people. So while they had something that was quite useful, it was not something that could be easily reproduced because that company didn't even know what was the secret sauce in that meteor. The second part, written description. You actually possess what you claim to be your invention. The famous Supreme Court case on that was Eli Lilly, where they tried to claim the gene for human insulin. What they had, though, was the gene for rat insulin. Well, back then, it wasn't so easy to all of a sudden have the human gene just because you had the gene from rat. These two parts, enablement and written description, are very critical in the life sciences, and it's becoming applied more often in the mechanical and electrical engineering realms as well. Novelty, it has to be new. The US now is part of a first to file system. We used to be a first to invent system. You may have heard in the literature about the patent fight between MIT and Cal Berkeley over the CRISPR technology. That was applied for at the time where the US was a first to invent system. So now it's a race to the patent office, not figuring out who discovered something first. Because we're a first to file system, prior art has a much bigger impact now. There is a grace period, which I'll touch upon, but if it's already been described, it's not new. The other component of that is, well, what if it's not exactly the same thing as what you invented? Would it have been obvious? So let's say we had a widget where the invention is A plus B plus C and E. And we've got 3 publications out there. Publication 1 discloses A and B. Publication 2 discloses a widget with C and D. And then publication 3 discloses a widget with E. Is it obvious taking those 3 publications to then come up with your invention of A, B, C, and E? In other words, without D. And that's a legal determination. Often, your own lab's publications can be the hardest ones to overcome as to what's obvious. Because often in your scientific publications, you'll talk about what this could mean. You'll talk about how maybe it could be varied. Doesn't mean you've got the data to substantiate it, but the thought gives the motivation of somebody else with your skill level to modify what you've published. Inventorship. This is clearly a legal determination. It's not authorship on a publication. What's the key difference? Invention focuses on the conception of the invention, not actually reducing it to practice, and I'll touch on that later. I do want to emphasize here, when you submit an invention disclosure, you can list who you think contributed to the invention, but the answer on who is an inventor will not occur until the time we have patent claims and a patent attorney makes that determination on who was involved with that conception. This is a very busy slide. I'm not going to go into a lot of detail, but what I wanted to illustrate, though, is that this very first part about before public disclosure. If you file the invention disclosure before you've published, or before you've presented, or before your student has defended their master's or PhD, those are considered public presentations. So if before it's been disclosed, we can pursue international IP rights. If it's already been disclosed, well, we've got a 12-month grace period to preserve U.S. property rights, but we've lost global rights. Generally, between the first patent filing, what we call provisional filing, 12 months later, we can convert that to say, okay, we really want to pursue a patent. There's a couple of different ways we can do that. what we call patent prosecution. That's with arguments, legal arguments made before the patent office. That generally takes 3 to 5 years. The patent term starts from when you convert that provisional application. And so that's where you start ticking the clock for how long your patent is good for. What's the cost? Well, it can run from $10,000 to $35,000 to successfully obtain a U.S. patent. If you want to pursue foreign patents, now you're talking over $100,000, and that could be per country. So when we evaluate market potential, we take into account is the market size large enough to justify the expenditure. I had a really great little invention to prevent sprinkler heads from freezing when crops were being watered during freezes. The problem was you only have so many sprinkler heads in a field. The idea was that these covers could be sold for about $5 each. Well, you multiply that by the number of sprinkler heads and those growing zones where you would have this problem. And if you're talking $30,000 in patent costs, how many of these do you need to sell to make up just that cost? So it really wasn't one of those things worth investing the money on a patent for a solution which is a real world solution. But guess what? You don't have to have a patent to get something on market. But this is generally how we take the approach. Some of you may know of some of the university inventions. Emory University made over $300 million in royalties on their developments for HIV drugs. It built them a new chemistry building, among other things. University of Georgia, Tim used to be there. Restasis was an eye drop for dry eye, hugely successful for Allergan. That came from the University of Georgia. Stanford was involved with recombinant DNA technology. Georgetown, CAT scans, SUNY, MRI, MIT, Bose speakers, CRISPR. Here at NC State, LED light bulbs formed a startup company called Cree, which later became Wolfspeed. You may know Wolfspeed for their work on semiconductors these days. We've also got an exciting new technology, a mosquito repellent, for an NC State startup called Mimicai. We hope that that product will be on market next spring. So the nitty-gritty, what rights does a patent provide? It only gives you one right, the right to exclude others. The right to exclude others from making, using, selling, or offering to sell within the U.S. or having imported into the U.S. a patented invention. It doesn't give you the right to practice your own invention, and I'll touch on that in a minute. That means you can infringe the rights of a third-party patent. In that case, you're going to need to have what we call freedom to operate. So freedom to operate. Here's an example. Let's say you've got a patent that issued in 2010, and it's for a paper bag with a handle. Well, a patent issued in 2009 for a paper bag. You see how your invention of a paper bag with a handle falls under just any paper bag. How would you make that work business-wise? Well, to practice your invention, you would take a license to the owner of that patent for a paper bag. And that's how business works. If you've used Bluetooth technology, DVD technology, the technology that went into those products came from multiple places. They pool the patents on that. And that's how business moves forward. Here at NC State, our policies for intellectual property are linked here in the slide. NC State will own inventions that arise from research conducted with university administered funds, research grants, sponsored research. And that work has to be conducted within the scope of your employment or work carried out on university time or expense. Many other institutions have these similar standards. You also, or it has to be a substantial use of university resources. That could be laboratory space. Our office, Office of Technology Licensing, manages all those inventions which are owned by the university. What does that mean by manage? Well, we evaluate, we market, we license. We make sure that the company who's licensed complies with the license. So now here's the aspect where everything gets started with an invention disclosure. Once an innovation is conceived, and I use the word innovation because we don't know yet if it's an invention, is partially reduced to practice. And under the best circumstances, you've not disclosed it to the public, you would submit an invention disclosure to an office such as mine. As I mentioned, let's say you've already given a presentation at a conference, or a student has given a presentation even within your own department. And by the way, those types of presentations, those are public presentations. There's no confidentiality there. We've got 1 year from that date to still file to pursue U.S. patent rights. This was to protect the small inventors in the U.S. We cannot dictate what other countries grant for grace periods. So this is why, if you've already disclosed your invention, the only thing remaining are U.S. rights. Often that's the biggest market anyway. I've included the link here for NC State folks on how you would submit an invention disclosure. You provide the title of the invention, the description of the invention. Tell us if you've had any prior public disclosures. Provide to us the posters or the slides, the abstracts, whatever's been disseminated publicly. Identify who you think the innovators are. Tell us how the work was paid for, because there may be obligations. One, if it was federally funded, we have to report whether we're going to pursue commercialization. We have to report that to the funding agency. That could be National Science Foundation, it could be NIH, it could be USDA, it could be Department of Defense. If this was a sponsored research agreement, maybe the sponsor retains some intellectual property rights. We need to know that information up front. If you already know of commercial partners, industry players who might be interested, help us identify those places and we'll try to connect with them to see if they have an interest in licensing. What if you collaborate with people at another institution? Here with the Bezos Fund, I understand there's UNC Pembroke, there's Duke, there's North Carolina A&T, there's also, I think, one of the technical schools involved, Forsyth, is that correct? And then, of course, the folks here at NC State. If that happens, each innovator should disclose the invention to the respective institution. Let's say if your lab has 5 people, one person needs to take the lead and report it. All 5 don't need to do that. All 5 of you will have to electronically sign that document, though. If you've worked with other institutions, our office will work with your institution to collaborate on how we move forward with things. It's usually in the form of an agreement between institutions. If you're at State, Duke, North Carolina A&T, or UNC Pembroke, here are links of how you can reach out to your offices with your invention disclosures. Our process. This flow diagram is actually very useful. So the very first step is you guys are doing the research. You disclose to us what you've been doing, what you think you've discovered. We'll evaluate that, and based on that evaluation, well, we may say, further develop this. I'll use the example often with plants, modified plants. The initial research is done in a species known as Arabidopsis thaliana. Now the problem is that's not a crop, but if that trait were transferred into corn or soybean, that is something that could be of interest. So in a case like that, we may say further develop it and a relevant crop. We may have to make sure that however the work was funded, we're complying with our obligations to report, our obligations to render an option to the funding agency or the company. Or we may just say, this is not something that, as I use the sprinkler head, that was a situation where, first of all, the person who did that on their own time. It was not part of their duties, so that person owned it anyway. But even if he requested us to take it over, the cost did not balance with what the commercial potential was. And we could release rights to the inventor if the university owns it, but declines, and if the PI wishes to, on their own, advance it. Or we could just say, publish your work. Get it out there like you normally would. Sometimes market interest develops from those publications. If this is something that could have value, we'll attempt to market it. We'll create marketing sheets, we'll advertise it, we'll post it on LinkedIn as well as a commercial website. We'll directly reach out to our partners in industry to see if this is something of interest to them. At the same time, we'll try to protect intellectual property rights. That timing of marketing and protecting rights, it depends on each situation, so we're flexible. And then if we're successful, we'll license that out. As part of this process, you sometimes have to have discussions with other parties to maintain intellectual property rights, to maintain the ability from others from stealing your ideas. We need to get a confidentiality agreement in place. You needed to protect that non-public information to be able to have those conversations where you're discussing ideas without fear of that information getting out there. There could be a one-way confidentiality agreement, which is, let's say in this case, protecting the information from your university. A two-way confidentiality agreement, maybe the other party you're talking with wants to talk to you about their business capabilities, but they want to keep that confidential. That could be a two-way confidentiality agreement. The usual terms of confidentiality are no longer than 5 years. Jerry Sasser in our department is our senior agreements manager. I've given you the link to him. You would directly place that request with Jerry. Material transfer agreements. Why do you need them? Well, if you're sending materials out to another institution or a company, we need to have a material transfer agreement. We've got to make sure that that transfer of materials complies with policies of the university, in this case NC State, and sometimes it has to comply with certain laws of import and export. Each university's got an import and export department that's involved with policing such things. Question is, are you sending out materials or are you receiving materials? There's a questionnaire that Jerry will provide to you that will help him draft material transfer agreement and get those out. So both of those documents come through there. And Tim, let me know two things. One, time, and also if we've got any questions through the slides.
Anybody in here have any questions?
Okay. So who are we? Who is the Office of Technology Licensing? Well, we're former scientists or engineers. We do a market evaluation. Is this something of interest? We assess, well, is it patentable? What's already been published? What makes yours different? We'll see if this is something that has an interest from outside companies or perhaps a startup company. We'll handle the contract negotiations and drafting from confidentiality to material transfer to licensing to interinstitutional agreements. Then we'll look to try to commercialize that. We work with you folks to make sure that we're complying under any obligations under the funding agreements. Could be federal or private. We want to facilitate the transfer of those inventions and technologies to the market. It goes back to the theme of this. We're doing this to make a difference. The way we make a difference is we get it out there into the market with the goal to benefit the public. While the knowledge can be interesting, it may show up on your news, it may show up on the internet. Does that really move it forward? Our office is trying to move those things forward. So often what we'll do is we'll try to license those technologies either to an existing company or to help form a new startup that can then further develop and then perhaps commercialize the technology. And maybe later they will be ready to partner with a bigger company. Why do we do this? Well, we want to promote university research, discoveries, and do that with intellectual property. We want to raise the visibility of, in our case, NC State research, our facilities, and our expertise. We want to create new funding opportunities by strengthening ties with industry. Think about this. The Bezos Fund is a great collaboration. We want to be able to recruit and retain faculty who want their research translated into products. If we're lucky, we can also drive economic growth by doing this. Stimulate economic development. New jobs, new companies, new products. In the end, we hope we benefit the public. We make a difference. Circling back to inventorship, it's based on U.S. patent law. Who is an inventor? Well, it's got to be a person. It's not artificial intelligence. That's in the public debate these days. Inventor has to be a person. Co-authors on a paper are not necessarily inventors. It has to be a person who contributes to the conception of the invention. And inventorship cannot be determined until we have patent claims which have been drafted. I'll give you an example. Let's say I have a widget, and then the second claim is the widget of claim 1 that comprises a certain adhesive. So let's say innovator number 5 had that idea of the adhesive. What if in the end there is no patent claim that specifies the adhesive? Technically, innovator 5 is removed as an inventor because now there's no longer a claim tied to their contribution. That emphasizes that inventorship is based on patent claims. So, because a person reduces something to practice that does not make them an inventor, and here's an example of that. The idea is to use compound A to treat plant disease number 5. The reduction to practice is to conduct an experiment using compound A on those plants, controlled and diseased. The person who's reducing it to practice is not an inventor. The inventor is the one who came up with the idea for compound A to treat the disease. Now, finding the appropriate licensee. It could be an established company, or it could be a startup opportunity. Depends on the type of technology. Is it platform technology? Is it an incremental? Is it disruptive? If it's disruptive, often a startup company is best suited to advance it because they're the ones who believe in it, whereas everybody else doesn't. What stage of development is the technology? Is it ready to be commercialized? Does it require EPA approval? Does it require FDA approval? Those are the types of questions that have to be evaluated. How much R&D is required to commercialize it? Let's say if it's a therapeutic, you're talking about investigational new drug application. That's animal studies. You're talking about pharmacokinetic processing. Then you're talking about clinical trials. It's a long path. Whereas something that's ready to go to market, I've got a widget that doesn't require any government approval. I could be on market in 6 months. What are the hurdles to commercialization? I mentioned regulatory approvals. What's the patent landscape? Are there freedom to operate issues? Do I need to get a license from somebody? Here's an example of an established company, Tyson's Foods. Well, in 2018, they invested in a company called Memphis Meats. That was a startup, but that was partnering with an established company. Impossible Foods, which many of you have heard of, that started as a startup in 2011. It's not a one-size-fits-all. At NC State, there's revenue sharing under our patent policy. This falls under the Bayh-Dole Act, requiring that revenue get shared. Each university has their own metric on how this is done. Here at State, the revenues are distributed. 40% goes to the inventors or innovators. You guys get to decide how you want to split that up. Generally, the best way to play nice about it is all innovators get whatever proportion, whether or not they're an inventor in the end. That's kind of the nice way to do it. But we stay out of that. 5% goes back to the university. It's supposed to use to support activities for innovation and entrepreneurship. 5% goes back to the department. Again, to support innovation and entrepreneurship. The remaining 50% goes to a patent trust fund. That's how we operate. Our office has been pretty successful. We've formed almost 200 startups, over 800 commercialization agreements. Financing raised by NC State startups, $1.7 billion. We've had 1,500 plus patents that have been issued, 600 plus products to market. If you've had Howling Cow ice cream, that came out of NC State. Well, that's my presentation. I hope this collaboration, this initiative, will help us to make a difference. And I'm free for questions, and I think Tim has added in a link for you to complete for the survey.
Yeah, I'll come up here. Thank you, Devesh. Yeah, so if you follow that link that's listed there, I've added it to the calendar invite, so it's at the top of the notes section of the calendar invite. Click over there, it's 5 quick questions. Hopefully it won't be too painful. The idea is just to prove that you either came today, either online or in person, or watch this after the fact, so we can make sure to complete that training for intellectual property. I think, unique situation that we have with the Bezos Center for Sustainable Protein is that we have funding set aside specifically for intellectual property protection from the center. So at least at NC State, I think we can probably figure out how it will work with our partner institutions as well. But as long as we're leading the prosecution, we have standalone funding set aside specifically to file patents on intellectual property created from the center. So that is a unique situation. We don't have that for everybody around campus. So definitely take advantage of that. Hopefully we see great things come out of the research being done. We know most of you are just getting started, so you haven't really had a ton of time to get the innovations rolling out of the lab. But as they do, as you start to get publications put together, please make sure to look at that disclosure slide that Devesh shared on when and how you do it, and then the links for your specific organization or your institution of how to submit a disclosure. Because we unfortunately can't do very much unless we get a disclosure from you. So that's kind of what kicks off the process for us to be able to file and hopefully protect that innovation as it moves forward. On Friday, we'll dig deep into kind of why we briefly mentioned it here, just on licensing to large company versus startup company. I'll go into detail about what is a startup company, because you probably have lots of different maybe experiences or heard of different things about what that means, how we work with large corporations, because that's typically a good partner for a lot of what we're doing. And again, with the center, we have industry partners who are part of the center as well. So I think the number is around 30 already that we've identified as part of the launching of the center. We'll be formalizing that process. We're putting together agreements with them as we speak to bring them in to complete those confidential disclosure and MTA agreements with them as it moves forward. So there's huge opportunity. We basically have built-in industry partners as part of the center. We have built-in intellectual property funding set aside for this, and we have funding for events like this, for training, as well as some acceleration funds that we're calling boost funds that will help kind of kick these things off as they get moving forward to hopefully either spin out a company or answer key market information, get grant funding for the startup companies that spin out of this as we move forward.